Michael Jordan's NASCAR team just suffered a devastating legal defeat, potentially costing them tens of millions of dollars. The Fourth Circuit Court of Appeals struck a big blow to 23XI Racing and Front Row Motorsports by overturning the order that allowed them to compete as chartered teams. What occurred next will take you by surprise. Both parties appear to have no option but to move on in the worst possible way. NASCAR's charter structure is analogous to the franchise concept in professional sports. Each charter guarantees entrance into every Cup Series event and a higher part of the season-ending points pool. Every week, the system covers 36 chartered automobiles out of a total field of 40. In September 2024, NASCAR announced a new charter agreement with 15 teams. The offer was straightforward: take it or leave it. 13 clubs signed the agreement, with some arguing there was little space for negotiation. Only 2 teams declined to sign: 23XI Racing, co-owned by NBA legend Michael Jordan and veteran driver Denny Hamlin, and Front Row Motorsports, led by millionaire Bob Jenkins. The financial stakes were massive. Denny Hamlin later admitted that the difference between running as open teams and chartered entries was tens of millions of dollars. In October 2024, both teams filed an antitrust complaint against NASCAR, alleging monopolistic and anti-competitive behavior. The teams claimed that NASCAR's charter agreement had a clause prohibiting them from suing NASCAR for anti-competitive behavior. In December 2024, U.S. District Court Judge Kenneth Bell granted a preliminary injunction in favor of the teams. The injunction allowed 23XI Racing and Front Row Motorsports to compete as chartered teams throughout the 2025 season while their lawsuit was pending. The teams received all of the benefits of chartered status, such as guaranteed starting positions and full financial pay. The judge found that NASCAR's charter agreement likely violated antitrust laws. For a moment, it appeared like Michael Jordan's team had struck gold. But NASCAR wasn't finished. NASCAR swiftly appealed the district court's judgment to the Fourth Circuit Court of Appeals. During a May 2025 hearing, it became evident that the team's legal strategy was in significant peril. Throughout the proceedings, Judge Paul V. Niemeyer openly challenged the team's rationale. Niemeyer said, "I had thought coming in, and you can correct me, that the district court concluded that the lawsuit release clause was anti-competitive, and therefore, to protect your antitrust claims, the court wanted you to be able to race but without a contract that included the release." The judge resumed his pointed questions. "My concern, and I'll just lay it out there, I don't understand the Section 2 analysis. What we need to have is the exercise of monopoly power to exclude competition. I can't see why a release addresses competition in any sense. If you don't want the contract, you don't enter into it and you sue. But if you do want the contract, you enter into it and you've given up past releases. But the omega is that you can't have your cake and eat it too." On June 5, 2025, the 3-judge appellate panel released their decision. NASCAR won. The court's decision was stern and decisive. In short, because we have found no support for the proposition that a business entity or person violates the antitrust laws by requiring a prospective participant to give a release for past conduct as a condition for doing business, we cannot conclude that the plaintiffs made a clear showing that they were likely to succeed on the merits of that theory. And without satisfaction of the likelihood of success element, the plaintiffs were not entitled to a preliminary injunction. The injunction was reversed. 23XI Racing and Front Row Motorsports faced the loss of their charter status. The appeals court judgment has immediate financial repercussions for both teams. Without charter protection, the teams would become open teams, forced to qualify for races each week based on their speed. More importantly, they would only receive a percentage of the funding allocated to chartered teams. Cup Series teams rely heavily on NASCAR purse and point fund money, with chartered teams earning a significantly higher amount than open teams. The finances of 23XI and Front Row Motorsports were seriously hit. The situation grew more difficult as both teams boosted their automobile count from 2 to 3 during the off-season. They obtained more charters from the now-defunct Stewart-Haas racing team, which collapsed at the end of the 2024 season. Since Stewart-Haas Racing no longer exists, NASCAR would most likely take over ownership of these charters. If the teams lose their charter status, other chartered teams may receive a greater part of the cash set aside for chartered teams. Front Row Motorsports currently fields vehicles for Todd Gilliland, Noah Gragson, and Zane Smith. Riley Herbst, Tyler Reddick, and Bubba Wallace all have vehicles with 23XI Racing. Tyler Reddick's predicament adds another layer of complexity. The driver is now 6th in the Cup Series standings, having won the regular season championship last year. He competed for the Cup Championship in November 2024. According to 2311 Racing, Reddick's contract would have made him a free agent if the team hadn't guaranteed him a charter-protected car. Neither 2311 nor Front Row are currently in danger of failing to qualify for races if charter protection is lifted. No race since the Daytona 500 has had more than 40 teams contend for the 40 starting places. Except for one race since the 500, there has not been a full grid. Money remains an important component. NASCAR did not stop at appealing the injunction. In March 2025, NASCAR filed counterclaims against 2311 Racing, Front Row Motorsports, and Curtis Polk, Michael Jordan's longtime business manager. NASCAR's counterclaim claimed that the teams and Polk conspired to threaten, coerce, and extort NASCAR into meeting its demands for better contract and financial terms. The most explosive charges involved Curtis Polk's role as an alleged ringleader. NASCAR stated that Polk coordinated behind-the-scenes efforts by all 15 charter-holding teams to avoid individual discussions. Polk was accused by the governing organization of attempting to establish a cartel that threatened to boycott races. NASCAR's attorneys even used a Benjamin Franklin quote that Polk allegedly provided to the 15 organizations. "We must all hang together, or most assuredly, we shall all hang separately." NASCAR claimed that this statement, and others like it, were an attempt to stymie fair competition. The sanctioning group indicated that the teams intended to boycott the 2024 Daytona qualifying events and had already missed a meeting with NASCAR officials. NASCAR knew the next step was they could boycott a race, which was a threat they had to take seriously, said NASCAR's lawyer, Lawrence Buterman. Jeffrey Kessler, the renowned 71-year-old antitrust attorney who represented the teams, found himself fighting on multiple fronts. Kessler had previously won high-profile sports cases, including the NCAA lowering its collegiate athlete salary cap, the U.S. women's national soccer team's pay discrimination victory, and Tom Brady's successful appeal in the Deflategate scandal. However, this case presented distinct challenges. Kessler insisted that the Benjamin Franklin statement was derived from confidential discussions and should not have been made public. He maintained that NASCAR's claims did not show any criminal activity, citing the fact that coordinated negotiating is a normal method in commercial conversations. NASCAR knows it has no defense to the monopolization case, so they have come up with this claim about joint negotiations, which they agreed to, never objected to, and now suddenly it's an antitrust violation, Kessler said outside court. It makes absolutely no sense. It's not going to help them deflect from the monopolizing they have done in this market and the harm they have inflicted. Kessler deemed Polk's charges false, unfounded, and frankly beneath the dignity of my adversary to even make those type of comments, which he should know better about. Despite his education and renown, Kessler's arguments did not sway the appellate court. On June 18, 2025, United States District Judge Kenneth Bell held a nearly 2-hour hearing to assess the team's motion to dismiss NASCAR's counterclaims. The session highlighted the bench's growing displeasure with the escalating legal fight. "It's hard to picture a winner if this goes to the mat, or to the flag in this case," Judge Bell said during the hearings. "It scares me to death to think about what all this is costing." Bell pressed both sides on their aims in the months-long antitrust case involving the stock car series. Throughout the hearing, the judge stressed the potential financial and reputational harm that allowing the case to proceed to trial would have for all parties involved. When asked what the teams wanted if they won, Kessler gave an ambitious list of demands. The attorney suggested that NASCAR may sell off its racetracks, 11 of which hold top Cup Series races. The plaintiffs also want their financial damages raised and the opportunity to compete in non-NASCAR sanctioned races using NASCAR-exclusive next-gen vehicles. Essentially, the teams are arguing not only for a thorough overhaul of the sport's economic model, but also for freedom from NASCAR's grip on competition and ownership rights. The court's final decision is still pending, but the enormity of what is at stake is becoming clear. NASCAR's fundamental structure, economic climate, and governance model are all under risk. If the case proceeds, it may reveal faults in the charter structure, paving the possibility for dramatic changes in how the sport is organized. However, if NASCAR wins, it will send a clear message. Dissent will not be tolerated, and the league will retain ultimate control over its economic and legal framework. In this scenario, Jordan and Hamlin's efforts to promote change could serve as a cautionary tale for others. However, if they are successful, it may spark a revolt among mid-tier and independent teams, ushering in a new era of team empowerment in NASCAR. One thing is clear, this is no longer just a racing story. It's a legal battle between established power and modern upheaval. And NASCAR's future may be rewritten in court rather than on the track.